ranchers that put food on our tables.
The water is what matters to all of us and what we all need. For irrigation diversion projects associated with agriculture, we need cool, clean water. Trout fishermen downstream needs cool, clean water. The River District acts as a great intermediary between all of those needs. The river is what binds us all.
This is your water. These are your rivers, and this is your Colorado River District. Learn more at coloradoriverdistrict.org.
Well, hi, this is Andy Mueller. I'm the general manager. I'm sorry, I think I hit mute in that process. I just want to thank you all for joining us here today for kicking off our annual seminar. It's a little different this year, just like almost everything else that we're experiencing in the COVID times. We're going to be doing this virtually. We're going to have 4 sessions every lunchtime for 4 days here this week. Today, obviously, Water 101 from a West Slope perspective. And then tomorrow, we're bringing in a great discussion about waterworks, the Colorado River District in action. And that's a really interesting panel discussion on a number of activities that the River District is involved in throughout the Western Slope. On Wednesday, heating up to talk about why river flows are down. That's a discussion where we're going to bring in a number of different perspectives on a national and regional level, bring in the discussion from both the upper basin and lower basin discussion here in the Colorado River, talk about what's going on with the flow of the river. And then on Thursday, we're going to talk about of primary importance, the secondary economic impacts of demand management. And that's really a really interesting discussion too about our new secondary economic impact study that's coming out this week, just released this morning publicly. We really look forward to diving into that. And we want to welcome all of you to join us every day if you can. If you're not able to do that at lunch, we would encourage you to log in later and find those videos free of charge on our YouTube channel. I want to just run over a couple of quick things during today's session. As with all of our sessions, if you can use the Q&A function down at the bottom of your screen, you're welcome to give questions, provide questions throughout the presentation for panelists. Today, I will try to work in the questions that I see and am able to understand into our discussion as we go along. But at the end, we're going to have hopefully a 10-minute question and answer session. Remember, Water 101 is designed to help the West Slope, help folks who live within the Colorado River District understand the importance of water. It's long been our perspective that knowledge is power. Water fluency is really important for the protection of West Slope water resources. Understanding what the framework is, the legal framework for all of our use of water here on the West Slope and throughout the state, even the entire basin on the Colorado River, is really critical to understand for as many of our citizens on the West Slope as possible. So we're bringing this presentation to you today to really help hopefully increase the level of fluency in water language, in water knowledge. If there are questions you have, again, no question is too basic. We want to make sure that we convey the information that we have to you. It's part of our job at the River District in protecting West Slope water. With me today, let me introduce Peter Fleming. He's our general counsel. He's been with the River District for at least 12 years, maybe longer. He says, I think what he says when he introduces himself is for a really long time. That's how it feels to Peter. And then we have Jason Turner, our senior counsel at the River District. So these gentlemen are both practicing attorneys. They represent the River District in numerous cases in water court and other venues. They are our legal eyes in the West Slopes, really leading authorities on how to protect West Slope water. They've been involved in far too many legal battles to count, but I'm really excited to have them here with us today. We don't normally let them see the light of day or the public, so this is kind of an exciting time for us. We're gonna go ahead and start out and just welcome both Peter and Jason on board. I think, Peter, I want to turn to you first because I think there's a key issue that we've got to learn about, and that's the difference between water in our western states and water in the east. It seems like there are two different philosophies, legal structures, and if you could touch on that and maybe help us understand why Colorado looks at things under the system that it does. Peter?
Sure. Thanks, Andy. And thanks everybody for zooming in to today's session of our seminar. We really appreciate everybody participating. The thing about our great country is, of course, we have a system of federal laws that overlay all 50 states, and then the states have their own individual laws. For the most part, in many states, individual laws tend to be, if they can be different, but they might be just slightly tweaked. In Colorado, the speed limit's 75. In parts of Utah, they let you drive 80 miles an hour. So, small variations. The difference between water law and how we allocate water in the West, in the western states, and how we allocate water in the eastern states is really almost 180 degrees. So it's pretty interesting from that perspective alone. Historically, folks have drawn a line, a theoretical line of sorts, along the 100th meridian, separating the western states from the eastern states. And that 100th meridian, and if Alicia, if you're able to just post up that first slide that shows the west states and the eastern states, the dry states are the ones obviously to the west of this line. That's the blue line there is the drawn, the 100th meridian goes right through North Dakota, South Dakota, Nebraska, Kansas, and so forth. And that's basically everything west of that line historically has been where where agriculture is not productive unless artificial irrigation is applied, unless man goes out there and applies water to the land in order to grow a crop. You can't grow a crop reliably west of the 100th meridian without irrigation. And of course, in the eastern states, for the most part, you don't have to apply irrigation. That's why we have this separation. East of the 100th meridian, in those wet states, the law of how water is allocated and its use is generally termed the riparian doctrine. And what that means is if you own property and your property borders that water, then you have a reasonable right to the use of a portion of that water just by virtue of the ownership of your property that is adjoins that riparian sector, whether it's a lake or a stream or river. But your use is not exclusive. It can only be reasonable, whatever that means. That's kind of what the courts say is reasonable. And when you use your use of it also has to take into account the public's use, what is of public benefit for that. So you might have to take into account your downstream neighbor or somebody downstream quite a ways away. That can be both good and bad depending upon your location on the river. West of this line, the 100th meridian, we have what we call the prior appropriation system of water allocation. Some will also term this the Colorado doctrine, strict doctrine of prior appropriation. And it's called the Colorado doctrine because the prior appropriation system essentially arose in the state of Colorado when it was being settled by miners, effectively. And the prior appropriation basically is a fancy term for first in time, first in right. So if you came and you were using water, you had taken it out of the stream system and you applied it for irrigation, or you were using it to sluice a mine back in the 1850s or 60s, and somebody came in a year or two after you, diverted water upstream, and took some of the supply that you had historically enjoyed, you could go and say, hey, I was first in time, first in right. I'm a senior, you were a junior to my use, and therefore I get to curtail your use of water to the extent that I need that, because regardless of the use I'm making of it, so long as it's a beneficial use, I was first in time, I have the senior right. And that's the prior appropriation system. One of the interesting things is, as in contrast with the riparian system, where of course it's based on your property ownership, you could have a stream flowing through your property under the prior appropriation doctrine, and you have no right to it, no right to any of the water in that stream if you don't have a water right associated with it. It may be there one day, and somebody may appropriate water upstream of you down the line a few years later, and it might not be there. If you had not applied that water to beneficial use yourself, it's possible that somebody might take the water that historically flowed through your property. That's sort of a bizarre concept for people, from the eastern states to get used to. But that is in fact one of the key elements of the prior appropriation system. It's not based on your real property ownership. It's actually based on the diversion of water and the application of water to a beneficial use. You're on mute there, Andy.
Sorry, I just want to make sure that we said at some point during the use of Zoom, I inappropriately used my mute button and kept it on. It seems like it's the worst part of being on Zoom, or one of the worst parts. Hey, Peter, I really appreciate that insight that you just gave us in terms of why we have that prior appropriation doctrine. Can you talk a little bit about how our lawmakers, when our state was transitioning from a territory to becoming a state, how they enshrine that doctrine in our Constitution, and what that means for us on the West Slope? How does that work?
Sure, Andy, thanks. Well, because water is so scarce in the West, everybody's heard of, fights, shovel battles at the head gate of a ditch or between farmers or ranchers. We basically had to come up with a system of laws. And that law obviously is the prior appropriation system. Colorado felt so strongly about this that they enshrined the prior appropriation system into the state constitution, in 2 sections of the Constitution. And since this is a water law seminar, and we have accreditation for lawyers to get their continuing education credits, I'll cite some law actually. In the Colorado Constitution, in Article 16, Section 5, the drafters of the Colorado Constitution, the founders of our state, provided that the water of every natural stream, not heretofore appropriated, that's already a little lawyerly, isn't it? Not heretofore appropriated, not already appropriated, within the state is hereby declared to be the property of the public. And the same is dedicated to the use of the people of the state, subject to the appropriation as hereinafter provided. So what that basically is saying is that, yes, this water of every stream in the state is the public's water. It's an important point. We often think, those of us that are, practice in water law and own water rights, that we own water itself. We own that water. Well, we don't really own that water. The water is owned by the public, but the public's use of it, the public is subject to the use that somebody might make by appropriation. And again, what is an appropriation? Appropriation is the diversion of water and the application of that water to a beneficial use, such as agricultural irrigation, municipal uses, domestic uses, commercial or industrial uses such as mining. So as long as you're doing that, you can acquire a water right. But the water that has not been appropriated is the public's, subject to appropriation for others. And so that prior appropriation, again, means if I have it and I have a very senior priority, I can call out other water users, including my neighbor who is junior in priority to me. The founders then also included in Article 16, Section 6, that the right to divert, this is the common sort of the key sentence in the Constitution that folks point to when they look at the strict Colorado doctrine. The right to divert the unappropriated waters of any natural stream to beneficial uses shall never be denied. And water lawyers and water practitioners like to make a big deal out of that language, shall never be denied. When they see something as an infringement on their water use, well, they'll just go right to that constitutional clause and say, that's an infringement of my constitutional right to appropriate water. Sometimes they win on that, sometimes they don't. We do allow for some constraints on the appropriation of water, one of which I think Jason might talk about later is you can't appropriate water for speculative purposes. You can't go out and make an appropriation and hoard it in the hope merely that it's going to increase in value down the line. One of the interesting things about this, the right to appropriate unappropriated waters of any natural stream in the state, it's interesting is that's open to anybody. Here on the west slope of Colorado, within the river district's boundaries, we like to think of, it's west slope water. We provide by far the vast majority of water that arises within the state of Colorado. But this constitutional right to appropriate allows anybody in the state to appropriate and use water within the state of Colorado. And that has allowed for the existence of trans-mountain diversions, many trans-mountain diversions, a big history, big part of what the River District does is both fight for, against, and for mitigation to address the impacts of trans-mountain diversions. So because there's a constitutional right, a city like Denver, great and growing city of Denver, can come across the Continental Divide and make a legal appropriation of water for use, across the Continental Divide. They'll take it from Summit County, from Grand County, and apply it to beneficial use. Some might see that as a bad thing, as an evil. But the simple fact of the matter is it's part of our state and has allowed, frankly, for the growth and the quality of life that exists throughout the state, including on the Front Range.
So, Peter, that's an interesting point. I mean, the River District, we as we often say, and is frankly in our organic statute from the 1930s, we fight to protect West Slope water, right? And the waters of the Colorado River Basin. But you just said, well, our Constitution gives these cities, and I do want to be careful. You call it a great and growing city of Denver. That's a term out of some Supreme Court cases that recognizes the importance of planning for a water supply for cities that are growing, and that wasn't a judgment by you that it's a great and growing city. It was just a use of a legal term in our jurisprudence. So just to help others understand where Peter pulled that term out of. But I guess the question is, and I just want to take a brief moment from the Constitution and talk about, well, how is it that you and Jason and others at the River District, how do you, within that framework, that constitutional framework, limit or mitigate those diversions that go eastward out of the Colorado River and to feed the Front Range? What is it that you guys do at the legal department?
Well, it really is a lot of what we do here at the River District, and it's the history of the River District. The River District was created in 1937 in part, a very substantive part, to be a counterfoil, if you will, to diversions across the Continental Divide, to be an entity that would advocate to protect West Slope water. And that's really what we do to the best of our abilities. Obviously, the West Slope, we don't have the political or financial might of the Front Range, but we do have legal expertise. We have good arguments both in science and in law, and we have great advocates down at the legislature, and we will use all of those things to fight to keep water on the West Slope. And when we can't, because we can't completely overcome the constitutional right to appropriate that we just talked about, we negotiate, and we negotiate using the law and the facts as best we can. In many cases, prime examples being the Colorado River Cooperative Agreement that many folks have heard about, the Windy Gap Firming Project, IGA. We have negotiated, very complex and very lengthy agreements that take really years to negotiate and complete, where we've made both legal and policy decisions, both at the staff level and through our governing board, that the West Slope will receive a better outcome through a negotiated resolution than through pure litigation. And we're proud of those achievements. At the same time, not every dispute can be negotiated. And when we find ourselves in position where we can't negotiate a result, if we think we have a decent legal argument and decent factual argument, we will litigate that in court. Jason might talk about, I think, a little bit about a case called the Busk-Ivanhoe case, where we litigated that, went to the Supreme Court of the state of Colorado, and we won, and we ended up with a really a pretty good win for the West Slope. We turned that pretty good win into a negotiated resolution, which we think ended up with an even better outcome for the West Slope, but also recognized and provided some benefit to our fellow water users in the state.
Jason, do you have thoughts on maybe if you could just a little bit talk about Busk-Ivanhoe, Jason, and who are the parties, and how did that case come to be, and what were the theories that the River District was successful on in a case like that? I think it touches on a number of legal theories that are really interesting, and at least I feel unique to to Colorado water law. So, Jason.
Sure, thanks, Andy. Yeah, the Busk-Ivanhoe system is, it takes water out of here in Division 5 over into the Arkansas River Basin. It was originally decreed, the Trans Mountain Diversion was decreed for irrigation purposes. The city of Aurora and Pueblo Board of Waterworks purchased those water rights. The Pueblo Board of Waterworks changed their water rights. The city of Aurora came in, trying to remember when that was, 2010, 2011, I don't remember exactly, but finally, after owning that water for I think 20 plus years at that point, came in to change their water rights from irrigation purposes to uses within Aurora's service area, the municipality. When they were going to change that water, they basically looked at it in terms of what were their diversions through the tunnel, and that was the amount that they sought to change. We challenged that because, as Peter said, and one of the main components of a water right is the beneficial use of that water. And we said, wait a minute, no, you've got to demonstrate how you've beneficially used that water, and that beneficial use needs to be consistent with the decree that you have for that water right. Now remember, this was decreed for irrigation purposes. As it turned out, the water had been being stored, and I think Peter's going to talk a little bit about the distinction between direct flow water rights and storage water rights, but there was no provision in that early decree that allowed for the storage of that water right. So as Peter said, we actually kind of got it handed to us in the Division II Water Court, and then we appealed it to the Supreme Court and had a complete reversal. The court said, no, the terms of your decree are the terms of your decree. And that's what, it did not provide for storage. So any of that water that was stored, we need to look at that differently, because you didn't have the right to do that. And when you're changing a water right, and we'll get into this a little bit more later in depth, the amount of the water that you get to change, it's not your diversion rate, but it's the amount that you've applied to beneficial use consistent with your decree.
So Jason, just to stop, we're throwing out a lot of legal terms, but when we talk about the amount we use for beneficial use, the way I always look at that is the amount I actually consume, right? Like
Right.
If I'm watering just at my own house, if I'm watering my vegetable garden, if I water it, there's a certain amount of water that goes into the ground and returns, at least in theory, to the Colorado River and goes on its way to the next available appropriator. But the other part that I consume that goes into my plant and grows my carrots in my garden, that's a consumptive use amount, right? I mean, that's the part that you're talking about, that beneficial use amount. Is that right?
That's the historic consumptive use, yes. And that's the value in your water right there, is that amount that you've consumed.
Okay. All right. Well, you touched, thanks Jason for the little primer on Buscaglia. We may come back to that because it's got some really interesting additional theories as we move on that relate to some of the water topics we're talking about today. But you mentioned that Peter was going to talk about the difference between a direct flow and a storage right and a groundwater. And Peter, you want to run through some of the basics on this? I just think.
Sure. I mean, when you read an article about water, there's a lot of different numbers that are thrown around, and without some sort of context, it can be a little meaningless. And it's crazy in water court and in Colorado. There are cases and case law from the Colorado Supreme Court that involve disputes over really relatively small amounts of water. I mean, but even the small numbers, 1 CFS, you hear that term a lot. 1 CFS means 1 cubic foot per second. So if you picture a little ditch or a stream, and a cubic foot, which is about the size of a basketball, flowing through that stream, 1 cubic foot per second is a rate of flow. We measure direct flow water rights, like a ditch for an irrigation, a field that's irrigated, in terms of direct flow. 1 cubic feet per second equates to close to about 450 gallons per minute. So it's a fair amount. I forget I probably have the flow rate wrong, but your garden hose at your spigot in your house turned on full is about 7 gallons per minute, maybe. You hear that number sometimes. I might have that wrong, but
I think Peter, some of our newer appliances, the faucets we can buy or that are available that are water smart appliances, you turn your faucet on, it's about 1.5 gallons a minute. So you compare the flow of your kitchen faucet at 1.5, maybe 3 gallons a minute, if you've removed some of the limiters in the faucet, to 450 gallons a minute, which is a cubic foot per second, right? That's the
right. So that's 1 CFS, and it's not uncommon to have irrigation rights or municipal rights decreed for 10, 20, 100, several hundred, or 500 or 600 CFS, cubic feet per second, in the state. But you'll have big disputes over these, over relatively small amounts of water, gallons per minute, really in the terms of 20 or 15 gallons a minute. There are some Supreme Court cases that deal with amounts that small, to numbers like 1,000 CFS. And so it really runs the gamut in terms of the amount of flow. Same with the amount of storage. Storage is measured in acre feet as opposed to cubic feet per second. You know, a direct flow rate is measured as a rate of flow. Storage is a measurement of volume, and a storage right is, as opposed to a direct flow right, which is diverting it and applying it directly to beneficial use. A storage right is you know, either an on-channel or off-channel storage structure, such as a reservoir or a small dam, taking that water, putting it into the storage vessel, and keeping it there for subsequent use, releasing it later when the need arises. And storage is measured in terms of acre feet. And 1 acre foot is equivalent to about, again, roughly 325,000 gallons. An acre foot, the way that you often hear to visualize how much an acre foot is a football field covered a foot deep in water. So if you can think about that, that's 1 acre foot. To combine those two concepts in terms of rate of flow and storage, if you had a 1 CFS a ditch to feed a reservoir, and you stored that water, the rate of flow 1 CFS equals close to 2 acre feet per day. So if you have a water right that diverted at the rate of 1 CFS, you left it on for 1 day, at the end of that day, you would have approximately 2 acre feet of water in storage in your reservoir. And again, storage, sorry, go ahead, Andy.
650 gallons of water you get it with a 2 acre, 650,000 gallons of water, excuse me, that you'd have, right?
Right, correct.
Can I just stop for a minute while we're talking about storage water? I want to go back to something Jason said, see if we can't kind of help relate that Busk Ivanhoe case. Jason, we're talking about storage water, and if I store water in my reservoir, can I use it for whatever purpose I want once I've captured it? What does state law say about that? How do you tie that beneficial use into the storage of water? Is it mine to use however I want?
No, your decree, at the time that you go to water court to get your decree, you list the beneficial uses that you plan to make of that water. And so that gets enshrined in your decree, and that is what you are allowed to use that water for, provided it's not speculative at the time you go in and to get the decree.
So you've got to show when you get your decree, hey, I intend to use water to irrigate or to make electric power at my local power plant. But can we also, does the district, what kind of water rights does the district have the ability to file on? Do we have water that we can help fish habitat or river flows? What is, I know the district, I've seen it in our decrees on power production and irrigation and industrial and municipal uses. But what about river flows and fish habitat?
We do. We have gone in and we have decreed both our water rights for Wolford Mountain Reservoir, which we operate outside of Kremling, and then for the Elkhead enlargement, we have gotten decrees that specifically allow us to use water for in-river purposes, so to help fish, to help flows. It also impacts temperatures, etc. And then we've got, our water rights also cover more traditional uses that you'd expect to see throughout the district. Municipal irrigation, we have hydroelectric rights, etc.
Okay. Well, thank you. And then Peter, I interrupted you. I apologize. You were about to talk about another aspect of the classification of water rights, and I think that was groundwater. I don't want to.
Yeah, I'm not going to spend too much time on groundwater because for the most part, in the river district's boundaries and generally west of the Continental Divide, all groundwater, well, in fact, throughout the state, all groundwater is deemed to be tributary to the surface stream unless it is proven otherwise to be not tributary. And on the Front Range in particular, there are a number of groundwater basins that have been established to be not tributary to a surface stream. And you know, they can never prove it 100%, but they can generally show that you know, if you installed a big well and you pump that water out over 100 years, it wouldn't impact the surface stream, but for a teeny tiny amount, and they'll deem that to be non-tributary. That's the different. That type of non-tributary groundwater is distinct from the prior appropriation system, and that water is allocated according to property, the ownership of the property that overlies the groundwater. But we don't have a whole lot of that type of groundwater west of the Continental Divide. There are some mines and things like that that might have been deemed non-tributary a while ago, but I think it would be difficult to get that determination in today's day and age. Instead, we have this presumption that all groundwater is deemed tributary, so you can get a well, and that can be a water right just like any surface water right. You have to obtain a permit for any well from the state engineer's office, but you can also go in and adjudicate that just like you can any water right in the water court. And so your well could be subject to curtailment just like a surface water right can be as well if you're junior in priority to a senior user that is short of water.
So, I mean, that's a little bit unique in if we're looking at the Western states, right? I know California, for instance, is going through this huge process of finally prioritizing or adjudicating its groundwater uses because they've seen a huge draw on their groundwater that has caused significant land subsidence over the last 20 years. And I mean, they're in this huge process to quantify that groundwater use. But what you're saying in our system, if I had a well, it would be most likely in Western Colorado would be deemed a tributary well and therefore would be subject to the rights of prior appropriation. Does that make sense?
That's exactly right. Yeah, and in some of those other states, as you noted, California in particular, historically, they just pretended like there was no actual hydrologic connection between the surface and the groundwater. Sure, in some places, in some instances, that physical connection is attenuated over a period of years or longer. But in most cases, it's really not. I mean, it's pretty common sense that if you pull a lot of groundwater out of the stream, out of a well, 500 feet away from a stream that is normally a pretty dry stream, you're going to impact that stream.
That's interesting, Peter. I know you said you didn't want to spend a whole lot of time on groundwater, but I do want to touch on something. I was looking at the list of participants, and I think we've got a lot of people from the West Slope who may live outside of urban or domestic water providers. They don't have a water system, so they're on a well. Maybe they're on 35 acres. Does their water right have to have a decree, or is there something that exempts them occasionally from the system, or how does that work, Peter?
That's a great question, Andy. As in many things related to water law, there's an exception, and there are lots of exceptions. I used to equate water law to trying to learn a board game when you were a kid and your older brother or sister was teaching you how to play it and you thought you had the rules down, and then they said, no, I forgot to tell you about this other little thing. So there's lots of other little things in water law, and one of those is with respect to groundwater, because we have this presumption of being tributary. There's lots of folks that have as you say, live in rural areas, maybe they have a cabin on some property up in the mountains. They don't necessarily have a water right, but they do have a well. And the legislature a number of years ago recognized that this would be a big problem if people were called out of priority, if they had just a domestic water well that they used in their house, just for showering, cleaning, those sorts of purposes. If they were going to be called out, by maybe a big irrigation ditch 100 miles downstream, that would really present a hardship. And so the legislature came up with the concept of exempt wells. And there are different types of exempt wells. There's in-house only, and then there's some that allow for some outside use if you have, for example, if you're on 35 acres or more. But it depends very much on the specific property that you have and the exemption that you're going under. So there are these exemptions. I would point out that the exemption is not quite as ironclad as folks think it is. So what this exemption means is that, you know, even if it's very dry out, the stream is under call or under administration, which means a big senior water right is short of water and calling for water, that you're exempt. Well, you don't need to curtail your use. You can still take a shower, wash your dishes, etc. But that exemption is not completely ironclad. If there is a source available to you to augment your depletion or replace it in a way that protects those downstream uses, even though because they're short of water, you're expected to take advantage and to use those replacement sources. Very rare, if ever, that I've seen an exempt well actually called out, but in theory it could happen.
Well, thanks, Peter. Hey, before we turn, I think Jason's going to talk to us a little bit about the water court process, but I was looking at some of the questions, and there's one that came through, and rather than get into the specifics, just want to talk about it. It relates to your concept of that we have this right to appropriate water, and it doesn't have to be in the basin in which your property is even located, right? It could be 2 creeks over, it could be the Continental Divide away. But what about those people who, if they've got a farm and ranch that's 15 miles from the stream, and they 100 years ago, their predecessors put in a canal or a ditch that goes in those 15 miles, what used to be across maybe 4 or 5 other people's property, but today it ends up going across 30 different properties because there have been subdivisions. And so that ditch runs through people's property. The ditch owners have just the right, no matter what, to maintain that ditch and come in and out and fix it. And in addition to having the right, do they have any obligations to those underlying landowners? How does that work? Because it can be really confusing for people who aren't used to this.
Yeah, that's a tough one, and has spurred actually quite a lot of litigation, including litigation that has gone to the Supreme Court several times over, including some cases here locally in the Roaring Fork Valley. But the short of it is that yes, a ditch owner has the right to transport that water across your private property, and they have the right to go in and maintain that ditch as well. But as you point out, that's a right, but it's also an obligation. Has to be maintained to a reasonable level. Folks probably often will get into a tiff about, is a ditch being maintained? Maybe it's leaking, or it has blown out in a section, and that might generate a lawsuit. But the right to maintain is both a right and an obligation, and it's not unfettered. You can't expand that right beyond which the ditch historically enjoyed. In other words, the ditch owner can't say, "Hey, I own this water right in the ditch easement that goes through your property, and I used to maintain that with a width of 15 feet on either side of the ditch, but I got a bigger truck and now I need 25 feet. You can't do that. There's a lot of wiggle room within there, Andy, and it has generated a lot of litigation over the years.
Yeah, it's interesting, Peter. I want to hit one last concept that I think I ran into back when I lived in Uray County for years. We had some new ditches being filed on, new water rights, and you had to have I think the property owner, the water right owner, wanted to bring water across somebody else's property for the first time. And can you talk a little bit about the obligations in that circumstance to compensate the underlying landowner, and how do you?
Yeah, I mean, that's, one of the things about that constitutional right to appropriate and take water from a stream is, you could be taking water from a stream that's located on somebody else's property, and you do have a right to do that. But that right is not unfettered. You can't just take that person's land. You have to compensate them for the use of that property, the fair value that you're using. And, hopefully you could negotiate that price. If you're the landowner, you would want the price to be, the underlying landowner, you'd want the price to be high. If you're the person that is seeking to install a new ditch, you would want the price to be pretty low, because you probably got to go over several folks' property, or maybe dozens or more. If you can't reach an agreement, the water user, even a private water user, not just a public entity, has the right to condemn, effectively pay fair compensation for the use of that property.
So that's a pretty unique issue in Colorado law, to have a private water right owner with a right of condemnation. Or eminent domain, as we frequently hear it called. That's a pretty amazing right.
Yeah, it's completely, I mean, normally you would associate that right only with quote unquote the sovereign or some other type of governmental entity who has the right to take your property and pay you fair compensation for it. Eminent domain, condemnation, those are sort of the same thing. But almost always that's associated with a public entity, not a private entity.
Just an indication of how important water is in our state, that we have these really unique exceptions to the law and in situations where the law is applicable. Speaking of which, I want to turn to Jason. Jason, we've got what I think is a really unique system of dealing with water rights in our state. We've got these water courts, which when most people I know who didn't have the pain of going through and getting a degree in law and a background in water law, when you start talking about water courts, most people's eyes glaze over and they don't really pay attention. So Jason, I'd like to hear in a very interesting way, what are water courts and what do they do in our state?
Sure, and it is a unique system, Andy. In fact, Colorado is the only state in the country that has designated water courts, and these are district courts. We have 7 of them in Colorado. They're broken up by river basin primarily, and you have a judge who is appointed as the water judge. And so they hear all water cases within that division. The water court is where you also go to get your water right confirmed. At its most basic, a water right is the diversion of a specific quantity of water and placing that water to beneficial use. You then go to the water court to get your water right confirmed by the water court and its priority set, which then allows you, as Peter was talking about, first in time, first in right. That decree demonstrates your priority and it versus other junior users. As I said, most states in the West, in fact, none of the other states in the West have designated water courts. Most of their water rights are done administratively, typically through the Division of Water Resources or the state engineer's office, and you have a permit to use a certain amount of water. Another really unique aspect about our water courts is, like I said, they're district courts, and they have the jurisdiction to hear all matters that are related to water. In the state of Colorado, we typically have our district courts, then we don't like the decision we get from our district courts, we go to the Court of Appeals, and from the Court of Appeals, we can petition the Colorado Supreme Court to hear our case. The Supreme Court does not have to take every issue that comes before it, except in water law. And in fact, we even skip the Court of Appeals. So you have a direct appeal from Water Court to the Supreme Court. I think probably some of the justices think it's a little arcane, but we do have the ability to exercise that direct appeal of a water matter to the Supreme Court.
So again, another indication, Jason, right, of kind of a unique aspect of water law as opposed to so many others. Going back to an understanding when our state was founded of the fundamental bedrock importance of water and the ability to move water around and have certainty regarding its use. I think that's really interesting to me. You know, if you could maybe touch on something Peter talked about, but it relates to this prior appropriation system and the priority of water rights. Let's just say that Roaring Fork here is it's a dry year, like I don't know, say 2020, and say that there is a senior irrigation right on the Roaring Fork that's just not getting all the water they would have. And so senior, what would a senior right look like on the Roaring Fork? What date of appropriation? Do you have any idea? Would that be a 1950s right, or would that be a 1880s? What are we talking?
I think you're talking more 1880s.
Okay.
And, you know, it varies by basin. If you go up into, say, the Yampa River, it was developed later than the Colorado. And so people were going in and getting their decrees later. So but it varies by basin. And then, you know, of course, if you look to the South Platte, you've got very early water rights there as well. But,
Okay. So if this ranch, say, farm is not getting its water, who do they call? What do they do? Peter mentioned a call coming up. You know, someone puts a call on it. Who do they call? Do they call the water court? Do they call the river district? Who do they call?
typically the person you'll contact is the Division of Water Resources, and like our water courts, we also have division engineers that oversee each one of these water divisions. And then there are water commissioners who are kind of in charge of distributing the water by priority and by the decrees. So you'd be contacting your water commissioner if you weren't getting the amount of water you thought you were entitled to. And they would come out and take a look, and they would understand your priority. And if at that point, they would probably go up and start to turn some of those juniors off, those water rights that are junior to you.
Okay, so one of our audience members was wondering if that was done and like everybody above them got turned down just a little bit, or how does that work exactly? How do you handle that distribution? Is it a collective thing where we all jump in and work together, or is it really clear as to who gets turned off, and how do you decide that? I just want to make sure we're clear about this.
Well, it can be a collective thing if everybody chooses to work together. But under the strict prior appropriation doctrine, the water commissioner will start moving up the line from your senior water right to the next junior water rights, making water available to you. And the person that's junior to you, above you, may not be completely curtailed. They may still be able to take a little bit of water, but you are entitled to your decreed amount, providing you're not wasting it. But you are entitled to that decreed amount, okay, if it's available physically. So
if we know, for instance, the Roaring Fork or the Colorado River, let's talk about that as a main stem of the Colorado. We know that there are calls most years on the Colorado River. And the state, you're telling me the Division of Water Resources has people that enforce those calls. So when a senior's not getting their water. So right now someone's getting turned off. Well, does that mean that I can't go out on the Colorado River today and file on a water right that would bring a cubic foot of water per second over to my new organic farm, and that I can't start creating that today? Is there that doesn't seem fair to me.
You can, but you will, you're going to be a very junior water right on the system. So you still, as Peter mentioned, the right to appropriate the waters of the state shall never be denied. And you have the ability to go and file on a new water right with the recognition that it will be junior.
Okay, so it wouldn't have much certainty to it, is what you're saying.
That's correct.
As a water lawyer, would you tell me that I should go start that farm? or probably not? What would you tell me?
I would suggest that if you want to do that, perhaps you find some stored water that you can have a contractual relationship to have delivered to you. You know, I don't want to get into it too much, but you know, there are mechanisms, legal mechanisms by which you would be able to divert water out of the Colorado and replace it. We call that augmentation. And so if you had that contract for water, you could augment your diversions, which would allow you to take water out of priority. But again, you need a decree from the water court.
Okay, so those augmentation, that's why I see those contracts coming across my desk where I'm signing contracts with water users in Colorado. We're releasing water out of Wolford Mountain Reservoir to keep people in priority. Is that what we're doing there?
Yes, that's exactly what we're doing. You know, we provide an augmentation source.
Okay, that's great. You know, Jason, let's talk a little bit more. There's a whole nother world of water rights that I hear and I think people read about in the paper occasionally. There's this concept of an absolute water right versus a conditional water right. What does all that mean in English? What's going on?
So an absolute water right means that you have demonstrated that you have taken that specific amount of water, you've diverted it, and you've placed it to a beneficial use. You've had that overt act in which you've diverted the water from the stream and placed it to a beneficial use. Now, Colorado law also recognizes a conditional water right because the legislature understood that some of these projects, especially large projects, take a while to fully construct. And so they will allow you to kind of come in and save your place in the priority system. So save your place in line as long as you can demonstrate to the court that you are working diligently towards the development of that water right and that you can and will complete that appropriation. So, you know, a conditional water right, again, saves you that place in the priority system. So you come in and you file for it and you demonstrate to the court that, yes, I'm going to construct this. It's a big project. We haven't got it all done yet, but we are working diligently to do that. And the court, once you get that conditional water right, you have an obligation every 6 years to come in and demonstrate how you are diligently working towards completing that water right. And then once it's complete and you've demonstrated that to the court, you're granted what's called an absolute water right.
Okay. Well, that's a fascinating concept. So you basically get your place in line, and then Jason, do you just like, I get my place in line and I'm waiting to get into a big box store on Black Friday, right? And so I just put my lawn chair there and I can go away and not worry about it, and it'll be there when I come back?
No.
I don't have to worry about it? How does that work? Like, what if I own a conditional water right? What do I have to do to keep my place in line?
Well, I mean, some of the things that the court will look at, you know, what sort of expenditures have you made towards the development of that water right? Do you have engineering reports? Have you constructed some of the components of that water right? Kind of economically, can you construct these features? If you need government permits, where are you in that process? State and local permits.
You know, Jason, I'm going to interrupt you.
Sure.
Just for a sec on that. I don't want to get too much into war stories, but I was involved in a case when I was back in private practice where we actually won the case before the Colorado Supreme Court. Case had been appealed, and we won at the Supreme Court level while we lost the main legal issue. The main legal issue in that case was it was a diligence case, and the objector I represented, I was part of the team that was representing the applicant, claiming they had been diligent in the development of a very large water right. And we were saying, you know, we did X, Y, and Z, and we spent this money. The objector argued that, well, you got to prove that you can and will develop it. And we said, we did that when we appropriated it. You know, the law at the time was you only had to show that you can and will appropriate the water and that you're not holding it for speculative purposes at the time you actually made your initial appropriation, not in every 6-year diligence period. Well, the Supreme Court ruled against us on that point and said, no, when you come in for diligence, not only do you have to show what you've done actively in terms of developing that water right, but you have to demonstrate again that you can and will develop that water right. We call that the can and will doctrine. And so while we lost that legal issue, we did sort of scrape by and win the actual case. But that was just reminded me of that case when you were talking about the diligence requirements.
Well, you know, Peter, that's a really interesting point. I think that's the can and will, and I want to talk about this. I mean, so we've got a water short system in many of our rivers on the west slope. We know there are calls that come on with regular basis in most years, and then in years like this, we're even seeing the main stem of the Yampa getting called out with the senior right for at least some period of time. So what do you do if you're someone who needs a really solid supply of water? How do you take an existing water right and change it and use it in a different method? What's the process look like? And maybe Jason, if you could start on this. You know, if I'm you know a farmer and I want to change my water right, maybe I want to get into business with my brother who is a developer or my sister, and we're, as a family, we're going to try to put some houses on it. What do I have to do? How do I change that water right? Is it just gone and I have to start new in this and get in the end of the line in the water rights? What happens?
No, that's a great question. And yeah, one of the great attributes of a water right in Colorado is the ability to change it and not lose that priority. And you can change the point of diversion, you can change the place of use, you can change the type of use. So, you know, in your example, I think you were talking about, well, we're irrigating this ranch and now we've decided we're going to do a subdivision. So you would file what's called a change of water rights. And again, that's an application in the water court to change the type of use that you want to use your water. So you want to change it now from irrigation to, let's say, domestic municipal use. And as we talked about before, the piece of the water right that you get to change, it's not your diversion rate. It's not that 5 CFS that you have decreed. It's the amount that you have beneficially used over time. So that historic consumptive use. And you will get an engineer who will help you in determining what that historic consumptive use was for the crop that you used to irrigate. And you'll look at a reasonable period of time. Okay, so you'll take a snapshot of your use over a number of years, and you'll come up with an average of what that amount of water that you historically consumed, and that is the amount of water that you now have available to you for this new use, that amount that you've historically consumptively used.
Okay, interesting, Jason. You know, we're getting close to a time period where we need to see if there's some questions out there, and I do see some coming in. You know, the one thing I want to say, we're talking about this change in use, and Peter, maybe you can speak to this a little bit. The River District has taken some pretty strong positions against the buy and dry of agriculture, and it involves that change concept that Jason was just talking about, buying it, drying it up, and moving it somewhere else. And why is it that the River District has strong policies in favor of protecting agriculture? Why is that, Peter?
Sure. I mean, there's, you know, agriculture has intrinsic values to Colorado's heritage, its natural landscape, the use of land that really, I think, you know, are sort of like, you know, mom and apple pie, at least here on the West Slope, where these are things that are worthy of not just protection, but to try to do what we can to ensure that agriculture remains productive on the West Slope, so that we do have these great visual landscapes and the heritage that comes with irrigated agriculture on the West Slope. That's not to say that, you know, certain changes of water rights shouldn't happen. Sometimes a piece of agricultural land might be isolated or no longer productive and sort of beyond the stage. It's a property right, as we noted. Folks are entitled to sell, and housing development can be a natural occurrence in an area that is becoming developed. There's one thing to have a piece of property converted from an agricultural parcel to one on which housing development sits, where the water that was historically used on that piece of ag land is now used to supply the housing or the commercial properties that exist on the land today. Many of us in the West Slope, have chosen to settle in places like that. It's another thing to take water from land that has been historically irrigated, cease that irrigation, and move the water off of that land for another purpose far, far away. And yet it's another step further if to do so, you're doing so for the purpose of moving it across the Continental Divide for other purposes. If you look throughout Colorado, there are segments of rural Colorado that have experienced what we call this buy and dry. Buy the underlying property, you buy the water right, and maybe you don't even buy the underlying property, you just buy the water right, you dry up the land, you cease to irrigate it. And when that happens on a large scale basis, the impacts both visually to the landscape, but more importantly, probably economically to the local community can be devastating. And that has happened in certain areas in the state, particularly the southeast part of the state and the lower Arkansas Basin. There are some sort of unfortunate key examples where we really are trying to prevent that from happening on the West Slope.
Well, thanks, Peter. I want to just turn to a couple questions, and maybe Jason, I'll toss this one to you. Are there water rights? You talked about the river district having some water rights to keep improve fish habitat and for in-stream purposes, but I've heard about, there's a question I think leaning towards an in-stream flow. We all recognize that the beneficial uses have, and I guess we haven't talked about this that much, but they evolve as our society is evolving and our understanding and our values change. We've recognized water rights that didn't used to exist. So back in the 70s, the in-stream flow program came into place and said that the Colorado Water Conservation Board is the only entity that gets to file on an in-stream flow. What does that mean for a private party that might want to maintain a water flow for its commercial fishery, whether it's a recreational commercial fishery or some kind of an industrial use? Can they do that? Can they file on in-stream flows, and how does that work?
No, actually, the Colorado Water Conservation Board, by statute, is the only entity in Colorado that can have an in-stream flow. In fact, the River District in the mid-60s, because we have in our organic statute the ability to appropriate water for healthy fisheries. And so we made an attempt to appropriate a water right, and it would have been kind of a precursor to this in-stream flow notion. And we were challenged on that, and the Supreme Court said, no, we understand that your statute says that, but we're not willing to get that far away from Colorado water law. You've got to have a diversion in order to have a water right. You've got to divert that water from the stream. So as you pointed out, in the 70s, the state of Colorado recognized a need to provide water for the environment, to preserve the natural environment to a reasonable degree. And so it allowed the CWCB, the Colorado Water Conservation Board, to file for these in-stream flow rights. Now, there's a distinction because earlier I said, the River District has water that it stores that can be released for fishery purposes. That's not an in-stream flow right. That water has been diverted from the stream, captured and possessed by the River District, and then is released for a beneficial use. There's a case that went to the Supreme Court about this on Taylor Park Reservoir, in which that was identified as a beneficial use. But the Colorado Water Conservation Board is the only entity that can have an in-stream flow.
Okay. Interesting. And I, we've got water rights that, for instance, in Rudeye that we've leased for in-stream channel purposes. We've been trying to help the fishing habitat up there in the winter. It's affected by something called anchor ice, where the ice attaches to the bottom and can hurt the macroinvertebrate that the fish eat. So really creates some issues. And we're releasing water this winter and last winter under a lease agreement. I think it was the Roaring Fork Conservancy really approached us with this idea. Is that our in-stream flow purpose? Is that not an in-stream flow right, Jason? It just gets confusing. So can you?
Well, we have the, in fact, one of, we have contracts for the use of water out of Rudeye Reservoir. And in fact, one of our contracts allows us to release water in the winter for those anchor ice issues. So yes, we've done that. We did that last year, and I anticipate that we may be doing that again this year. And that is, we've contracted with the Colorado Water Conservation Board to make those releases, and the CWCB is paying for that water out of Rudeye.
So we're getting close to being up, but I have one question left for Peter. And before I do that, we apologize. We only had a short period of time to talk about Water 101 with everybody. Do want to draw everybody to hit the Water Education Colorado website. If you're interested in additional learning resources, we've got a link that we'll put in the chat. It brings you right to the Citizen's Guide on Water Law, and it's a really good description. It'll help kind of refresh or go back over a lot of these things. I think Peter was talking about the different types of aquifers in our state and whether they're tributary or not, and all that kind of stuff in the priority system. It's all in that WECO document, the Water Education Colorado Citizens Guide. So we're going to put that post up if we can. And then it looks like it might be in the Q&A section. So, hey, Peter, one last question. How do judges become water judges, and how does one become a water commissioner? How does this work?
Thanks, Andy. Let me just say real quick, I hate doing a talk on Water 101 when I don't have time to answer questions, because you usually get lots of really interesting questions, and I can see we're getting a lot of good ones here. And so we apologize for that. We would love to get to all of them. A water judge is actually just like any other judge. They usually serve with two hats. They're a normal district court judge, where they would consider normal things like a civil lawsuit or a criminal case. And then when they sit as a water judge, they put their water judge hat on, and then it's water court. And generally, most of the same rules of procedure apply, not entirely, but mostly. But a person becomes a water judge by being appointed, and they are appointed by the Supreme Court, who usually it will be a person that has been a judge for a while, that has shown that they can be a good judge, a good learner, and oftentimes it is the chief judge within the division. There are 7 water judges in Colorado, one for each of the 7 primary water basins. Colorado has obviously lots of different rivers, and they've been divided into water divisions by the state, and there's a water judge for each of those primary water basins, including within the river district's boundaries. The Colorado Basin, the water judge is located here in Glenwood Springs. Water division, that's Water Division 5. Water Division 6 is the Yampa and White Basin. The water judge sits in Steamboat Springs. Water Division 4 is the Gunnison River Basin, also in the river district's boundaries, and that judge is located in Montrose.
Hey, well, Peter, I appreciate it. I think we're running out of time. And like you said, we hate not answering questions. So our emails are posted in the chat box, Jason's, Peter's, and mine. If you have specific questions for one of us, if you could email us, we'd be happy to respond. Remember, none of the three of us can give you legal advice. These two guys are legal counsel to the district. They can talk about things. I'm a licensed attorney, but I'm not even practicing, so you don't want my advice on this anyway. But we can give you our opinions in general about what the law is. What I would encourage you to shoot those emails to us. Again, looking at the Water Education Colorado website. One other thing I would really encourage you to do is come to our next 3 sessions at the seminar. Sorry that we're doing this virtually this year. We'd much rather see you in person, but we do want to reach out. We think it's really important that people on the West Slope understand the issues that are facing us and have this understanding and knowledge of water law, because it gives you power. So thank you for coming in today and attending. We really appreciate it. And we look forward to hopefully next year returning in person to a seminar. Again, thank you very much, and look forward to having you join us in the future.
Thank you.
Thank you.
Thanks.